proceed.
Members of the jury, hearken to the indictments in the case of Commonwealth versus Aaron Hernandez. Indictment 2013-983-A, charging murder. At the Superior Court holding at Fall River, within and for the County of Bristol, for the transaction of criminal business on the first Monday of July, 2013. The jurors for the said Commonwealth, on their oath, present that Aaron Hernandez, on or about June 17, 2013, at North Attleboro in the County of Bristol aforesaid, did assault and beat Odin Lloyd with intent to murder him, and by such assault and beating did kill and murder the said Odin Lloyd in violation of General Laws, Chapter 265, Section 1, a true bill signed by the foreperson of the grand jury and the assistant district attorney. Indictment 2013-983-B, charging unlawful possession of a firearm while not at home or work. At the Superior Court holding at Fall River, within and for the County of Bristol, for the transaction of criminal business on the first Monday of July, 2013, the jurors for the said Commonwealth, on their oath, present that Aaron Hernandez, on or about June 17, 2013, at North Attleboro, in the County of Bristol aforesaid, did knowingly have in his possession or under his control in a vehicle a loaded or unloaded firearm as defined in General Laws, Chapter 140, Section 121, the defendant not being present in or on his residence or place of business, and not having in effect a license to carry firearms or otherwise being authorized or exempted by statute so to do, in violation of General Laws, Chapter 269, Section 10A, a true bill signed by the foreperson of the grand jury and the assistant district attorney. Indictment 2013-983-C, charging unlawful possession of ammunition without an FID card. At the Superior Court holding at Fall River, within and for the County of Bristol, for the transaction of criminal business on the first Monday of July, 2013, the jurors for the said Commonwealth, on their oath, present that Aaron Hernandez, on or about June 22, 2013, at North Attleboro in the County of Bristol aforesaid, did own or possess or transfer possession of ammunition without complying with the requirements relating to the firearms identification card provided for in Section 129C of Chapter 140 of the General Laws, in violation of General Laws, Chapter 269, Section 10H, a true bill signed by the foreperson of the grand jury and the assistant district attorney. To these indictments, the defendant has heretofore pleaded that he is not guilty, and for trial has put himself on the country, which country you are. You are now sworn to try the issues. If he is guilty, you will say so. If he is not guilty, you will say so, and no more. Hearken to the evidence.
As we begin, I want to tell you a few things about the trial of cases generally. At this time, in this case, there are 19 judges. You 18 men and women are the judges of the facts. You're the only judges of the facts. You alone determine what evidence to believe, how important the evidence is that you do believe, and what conclusions all the believable evidence leads you to. Ultimately, you must determine whether or not the Commonwealth has proved the charges beyond a reasonable doubt. You will have to consider and weigh the testimony of all the witnesses who will appear before you, and you alone will determine whether to believe any witness and the extent to which you believe any witness. The testimony of a law enforcement officer is to be treated the same as the testimony of any other witness. You must determine the facts based solely and entirely on the evidence as you see it and hear it right here in this courtroom, and on anything you may observe about the layout of the locations you see when we go on a view, and on nothing else whatsoever. No bias, no prejudice, no fear, no sympathy for anyone. Before the case will be presented to you, there are a number of aspects we should touch upon. First, keep your mind suspended throughout the entire trial proceeding. By that I mean don't stop making up your mind. You've heard no evidence at all yet, and when we stop taking evidence, the last witness is as important as the first, and the first as important as the last. So keep an open mind. Don't make up your minds while it's going along. Next, when you come into the courthouse, do not stop in any of the public areas inside or outside of the courthouse, but go directly to the jury room. The jury room will be your headquarters for the remainder of this trial. At no time should you use any entrance other than the one designated for jurors. Also, please park in the designated juror lot, and please be prompt. You should arrive at the parking lot between 8:15 and 8:30. As I have repeatedly instructed you, you cannot talk about this case, your jury service, or Mr. Hernandez with anyone, and do not allow anyone to talk to you about any of these things. This applies to communications with each other. Discussions can lead to conclusions being drawn or positions taken prematurely. Fairness requires you to keep an open mind about everything, and therefore you cannot discuss this case with each other until I instruct you to begin your deliberations. This prohibition against communications about this case, your jury service, and Mr. Hernandez applies as well to family members, friends, acquaintances, strangers, members of the media, co-workers, and employers, as well as lawyers, witnesses, and parties involved in this trial. You can notify your family and your employer that you are on jury duty and discuss the schedule if they need to know that, but please do not otherwise discuss any aspect of this case or Mr. Hernandez, including even that you are a juror on this particular case, until your service as jurors is complete and that you have been discharged by the court. The Jury Commissioner's Office will send you an official statement of your days of service in this case within a week or so after your service is complete, and you may show or give this form to your employer to confirm that you had served as a juror. If before that time you need confirmation that you are serving as a juror, please let the court officers know, and we'll give you a document confirming you're here with us as a juror. When I say you cannot talk about certain matters, I don't just mean face-to-face or telephone conversations. You cannot at any time before you are discharged as a juror communicate information about or in any way relevant to this case, Mr. Hernandez, or your jury service by using a mobile phone, computer, or any other kind of electronic device with communication capabilities, including access to the internet. You cannot use the internet or any text or instant or online messaging service or any chat room or blog or website, Facebook, LinkedIn, Twitter, Instagram, YouTube, Snapchat, or any other means to communicate anything about this case, Mr. Hernandez, or your jury service. And do not allow anyone to talk to you about this case, your jury service, or the defendant. Please remove yourself immediately from any conversation in which the case, Mr. Hernandez, or anything that might be relevant in any way to the case is being discussed. If anyone approaches you to discuss the case, you must decline to do so. If anyone persists in asking you about it, please inform one of the court officers immediately. Next, do not read, watch, or listen to any accounts of any aspect of this case. Anything that might be relevant in any way to the case, or anything about Mr. Hernandez in any news media outlet, social media, or other forum. Television, radio, newspaper, magazine, internet sites, social media, or any other source. You must completely disregard any information that you might encounter. it would be unfair to consider information from such sources because it is not evidence, and the parties will have no opportunity to challenge it or to challenge the accuracy of the information or to explain it. If despite your best efforts to avoid any news or social media reports or references, something comes to your attention, it is your sworn responsibility to put it aside immediately and to direct your attention elsewhere. Turn off or walk away from the TV, radio, or computer or electronic device, or put the newspaper down or other printed matter. In fact, you can take steps to try to avoid anything. If you look at a newspaper, have someone else cut out anything if there's anything about Mr. Hernandez or this case. If you go onto Facebook, if there's someone else that can look at it to make sure that there's nothing on the Facebook site that has that comes on when you turn it on that has anything to do with this case. Similarly, if you go to any news site on the internet, someone could look at that site to see that there is no headlines or anything that you might inadvertently come across. You also cannot conduct any investigation into any aspect of this case or try to get any information on your own about the case or do any research about the case or anything you think might be relevant in any way to this case or to Mr. Hernandez. That means no looking up anything in a reference book, encyclopedia, dictionary, or the news media. As I already told you, you may not try to get information by communicating with anyone. You also may not use any printed or electronic sources to seek out information about this case or about any of the issues or people involved in this case. That means no use of the internet, any internet service, any text or instant messaging service, any chat room, blog, or website, Facebook, LinkedIn, or YouTube, and no use of Twitter or Google, Yahoo, Safari, or any other search engine to conduct any research about this case or anything you think might be relevant to the case or the people involved in this case, or to receive any information about the case, Mr. Hernandez, or your jury service. You may not visit on your own any of the places involved in this case, and you cannot locate any areas about which you'll be hearing testimony by using internet maps or Google Earth. And do not ask or allow anyone else to do any of these things on your behalf. You cannot use for any purposes a computer or mobile phone or other electronic device while you're actually here inside the courtroom or during jury deliberations. You may use such devices during breaks, but once again, not to obtain or disclose any information about or relevant to the case. If any juror is exposed to outside information or if any juror has not followed these instructions, please notify the court officer in charge of your jury panel as soon as possible. I will be asking you each day whether you've had any difficulty in complying with these instructions. The reason for these cautions are simple but critically important. In order for your verdict to be fair, you must decide the case solely on the basis of the evidence and the law that is presented to you right here in the courtroom, and not from any other source. According to the oath which you have taken as jurors, you promised that you would well and truly try the issue between the Commonwealth and the defendant according to the law and the evidence. Any independent or outside information or influence would be improper and unfair to the parties. We need to ensure a fair, just, and equitable trial for all parties in this case. Next, you have the permission of the court to take notes. And so after the opening statements, one of the court officers will pass to each of you a notebook and a pencil. Your notes are private. At the end of each day, the notebooks will be collected and kept locked up overnight. No one but you will look at your notes. And when the trial is over, after you have finished deliberating, any notes that have been made will be destroyed. The notes are for you. The fact that I allow you to take notes does not mean that you have to. Many people understand things better if they're not distracted by taking notes, and of course, that's perfectly appropriate. You don't have to take notes about anything. Even if you do take notes, remember, most of your work in this trial must be done with your eyes, your ears, and your mind, and not with your fingers. So if you take notes, do so sparingly. Do not allow note-taking to distract you from your critical task of passing on the credibility, that is, the believability of the witnesses. To assist you in passing on the credibility, you should observe the demeanor and appearance of each witness on the witness stand here. Now, it's appropriate for the lawyers, as they examine witnesses, sometimes to approach a witness. But if a lawyer steps between you and the witness, and you can't see what the witness is saying as the witness answers the question, please raise your hand. I'll ask the lawyer to move so you can watch the witnesses as they answer the questions. It's also possible that a witness may drop his or her voice. If you can't hear, raise your hand. And the same is true of questions posed to witnesses. If you cannot hear what the lawyers are saying, do not hesitate to raise your hand, and I'll ask them to speak up. Generally, not today, but generally, I will be taking a recess every day at approximately 11 o'clock in the morning. On days when we are going to 4 o'clock, there'll generally be a lunch recess between 1 and 2. If any of you need a break other than at the usual time, please do not hesitate to raise your hand, and I'll stop and take a short recess. If it becomes necessary during the trial to communicate with me, you may send me a signed note through the court officer. Please do not communicate with me by any other means. As I've told you during this case, you may not communicate with the attorneys, witnesses, or the defendant at all. If you see any of them, they will not acknowledge you, or they'll walk the other way. It's perfectly appropriate, as we listen to the testimony of the witnesses, for a lawyer to object. In raising objections, the lawyers are carrying out their duties as trial lawyers, and you should not look negatively in any way on a lawyer who makes an objection. A witness is asked a question, a lawyer says objection, and then there's a ruling. I tell the lawyers, really, they're very skilled in the law, but I have the deciding power. I decide how the law works in this specific case. I may say sustained, which means that the witness doesn't have to answer the question, and you should disregard the question and not speculate as to what the answer might have been. Or I may say overruled, in which case the witness will answer the question, but don't give that answer any more weight than you would have given it had no objection been made. Sometimes the witness will answer the question before I rule, but I may still decide to sustain the objection or allow a motion to strike. If that happens, or if I say strike it out or disregard it, or words to that effect, then insofar as is humanly possible, you have to blot out what the witness has just said, because I will have decided that it plays no part legally in the trial of this case. Now, questions to witnesses, no matter how artfully phrased, are not evidence. Oral evidence consists only of the answers that you receive from the witnesses who are testifying under oath. Now, from time to time, I need to consult with the attorneys about questions of law that come up. We usually do that over there, what we call the sidebar. You saw us go over there when you were chosen. Or sometimes a recess will be called or the start of the trial delayed. I don't want you speculating about that. It will be necessary and perfectly appropriate from time to time to have such conferences about the law as matters come up during the course of the trial. If we are over there huddling, you should feel free to stand up and stretch, but please don't talk. When I rule, or if I instruct you on the law, or if I ask a question, do not take any of my words or expressions as any indication of my own opinion as to whether the Commonwealth has met its burden of proof in this case. If you come to believe during the course of the trial that I have any opinion as to any issue of fact, then disregard it. That is your area of responsibility and yours alone. Let's come to this case now. The Commonwealth brought this case. The Commonwealth made these charges against Aaron Hernandez. You should clearly understand that the pieces of paper which the clerk has just read to you, called indictments, are not themselves any evidence of guilt. An indictment is merely a piece of paper used to formally inform the defendant of the charges against him. An indictment is not evidence of anything. You must not draw any inference of guilt from the indictments or the fact that the defendant has been charged with a crime. The Commonwealth has to prove each essential element of each separate charge against the defendant, and the Commonwealth has to prove the guilt of the defendant beyond a reasonable doubt. Mr. Hernandez is presumed to be innocent unless and until he is proven guilty beyond a reasonable doubt by the Commonwealth. The law does not require a defendant to prove his innocence, so Mr. Hernandez doesn't have to explain anything. He doesn't have to testify. He doesn't have to put on any evidence. His lawyer doesn't have to make an opening statement, argue, or ask a single question. Remember, it's the Commonwealth that has to prove the case beyond a reasonable doubt, and that burden of proof never shifts. At the end of the trial, you must find the defendant not guilty unless the Commonwealth has proved to you beyond a reasonable doubt each element of the offenses with which the defendant is charged. The trial will proceed in the following order. First, the attorneys have an opportunity to give opening statements. After one of the assistant district attorneys makes his opening statement for the prosecution, one of the defense attorneys may choose to make an opening statement immediately, may postpone doing so until later, or may decide not to do so at all, since the burden of proof of proving guilt is always on the Commonwealth. Next, the prosecution will call what witnesses it has in support of the charges that have been made against the defendant. After that, the defendant may present evidence if he wishes to do so, but he is not obligated to do so. Remember, the burden of proof is always on the Commonwealth to prove that a defendant is guilty. The law does not require any defendant to prove his innocence, to testify, or to produce any evidence at all. After the last witness has testified, the lawyers have an opportunity to argue to you about what conclusions you might draw from the evidence that has been presented. After all the evidence and the attorney's arguments, I will explain in detail the law that you are to apply in your deliberations when you retire to consider your verdict. That's how the trial will work. You may have noticed as you came in that there are cameras in the courtroom. Only authorized members of the media are allowed to take pictures or record proceedings or use a mobile phone or other electronic device in the courtroom. Under the rules that govern the media's use of cameras in courtrooms in this state, no photographs of jurors can be taken. With these instructions, we're going to take a recess before proceeding to opening statements because I have some matters I need to go over with the attorneys. Remember, don't talk about the case with each other or anyone else. We'll bring you back shortly.
All rise for the jury, please.
I believe that the only motion in limine that council wanted to have decided prior to openings was the Commonwealth's second motion with respect to Mr. Paradis. Is that correct? That's correct. I have read all the briefs that were filed with respect to that, both by the Commonwealth and by the defense. If there's anything you wish to add, argue, you may.
Your Honor, I would say that in addition to the case citing that condition, the Commonwealth is coreless, which was decided just very recently by the SJC, speaks to all the issues that we raised in our submission temporal proximity, Corliss talks about a period of up to 18 months. These are all periods of time much shorter than that. Corliss also makes it plain that, contrary to what the defendant has suggested in his submission, this notion there needs to be a definite nexus between guns as to which testimony might reference during trial and the murder weapon is absolutely spurious. The relevance of the guns, number one, goes to the defendant's knowledge and ability to operate firearms. The Commonwealth's evidence here will show that the homicide was...
But nothing in California dealt with operation of a firearm, so why don't you go to your next argument?
Well, possession of the firearms.
Right, but you're saying to the extent it's relevant to his knowledge of how to operate, the fact that he indicated he possessed a firearm, how would that show knowledge of operation, unlike those cases where someone has been using a firearm at a firing range?
Your Honor, Corliss does make the point that now possession of firearms is a basis upon which one might infer a knowledge of their use and operation. So Corliss is very clear on that point, as is Suki, as is LeBlanc. There are lots of cases that we cite for that proposition. This notion that the defendant raises that there has to be this definite nexus between the gun and the murder weapon, it is absolutely incorrect on that basis. In addition, Your Honor, the Commonwealth's evidence will show that this homicide was committed by means of a joint venture. Multiple persons were involved, multiple persons were present at the time of the shooting, multiple persons were present in the defendant's home before and after, where guns might have been obtained. The notion that more than one person was armed is fully embraced by the Commonwealth's evidence, and so to the extent there were additional firearms present that may not have actually been the murder weapon used by the defendant, nonetheless these weapons might have been used by co-defendants in effecting the crime. In addition to that, Your Honor, Mr. Paradis talks about the type of weapon that might have been involved in terms of his ability to identify it, as he observed it in the nightstand. All those things are relevant to identifying.
I thought the last filing by the Commonwealth, excuse me, I thought the last filing by the Commonwealth, unlike some of the other previous statements, was that he did not in fact observe it. He observed a T-shirt and felt an object that he concluded was a gun, but he did not observe it. Is there a change yet again to Mr. Paradis' testimony?
No, Your Honor.
Projected
As
testimony.
I was saying when you spoke, he felt it through the cloth in the nightstand. I was able to approximate its size and weight and make observations of that kind of correlated to the weapon used in the offense. So for all those reasons, Your Honor, and in particular because of the extent to which Corliss makes it plain that temporal proximity is not required, or at least to the extent that we're talking about a matter of just a few weeks or months here, we're well within the time period contemplated by Corliss. In addition, the geographical proximity, which is something that the defendant raises in his submission, is not relevant here either. Natsuki, by coincidence, the observations were made of a weapon in California, just as was the situation here, Your Honor. And in Corliss, they also make the point that the geographical proximity is not relevant to the easy mobility of firearms, Your Honor.
What statements are there? I've seen what you indicate Mr. Paradis is now going to testify, and the defense has indicated the previous statements that were made. Where is there something that specifically has Mr. Paradis testifying as to the specific size of what he felt or the weight of what he felt? As you indicated, he would be able to testify as to size and weight. Where in the notes of the interview?
He felt it through the cloth in the drawer, and it is our representation today that testimony will embrace observations as to size, shape, and weight.
And is there any reason that that information has not previously been provided in the filings and as
well, to the
to?
extent that we're talking about someone who's feeling a firearm through a thin piece of cloth, it seems like a ready inference that the person doing so would have the ability to talk about, in general ways, about size and shape.
Well, but are you aware? I mean, has Mr. Paradis ever given a statement or made the Commonwealth aware of what size? Has he ever been asked what size it was he felt or what was the weight? There have been various statements as to what he has testified in the past or has said in the past, and the Commonwealth, in its motion limine indicated what he would testify here. I don't see anything specifically with respect to size or weight. So I'm asking you, do you in fact know what he will say as to size and weight, because you have obtained that information from him?
I do not stand here today, Your Honor. I know that he held the gun in his hands, stated that he had familiarity with firearms, was able to feel the gun through the cloth, and will make the observation that one might ordinarily make feeling an object through cloth, as I say, Your Honor, relating to size and shape.
Thank you.
Your Honor, I won't repeat what we've submitted in writing. This is the first we've heard that the witness is proposing to give yet another version in which he can supposedly testify about weight or size of the gun for the reasons of the temporal distance, the physical distance, and the several contradictions on substantive matters. I'd ask the court to exclude it, or at least in the alternative, have a voir dire before the witness is allowed to testify, and prohibit the Commonwealth from discussing this in its opening statement.
I am not going to rule on this motion prior to the opening. I will preclude the Commonwealth from referencing it in the opening. I think it is clear, given the pieces of information that come out, which is different from time to time as to what Mr. Paradise said or saw or did, that I would like to be able to hear from him, hear what his projected testimony is, and at that time I will rule. The fact that I am requiring a voir dire of Mr. Paradise does not mean that I have ruled that the other, that the court is inclined in the exercise of its discretion to allow him to testify, but I will defer ruling until any ruling on this matter until after he has testified as part of a voir dire.
Your Honor, can I ask you just to consider, there was two parts of that motion. One is obviously his statements, the defendant's statements that he had a 45 when he was in California, which is different than the separate occasion that you're referencing when there's a phone call made back to him to go into a drawer, take out an item that's wrapped in a T-shirt, and then his description of that. That's a separate
45
matter.
refers to the 45 in California.
Yes, Your
Right.
Honor.
I'm reserving on the issue entirely as to whether there can be any reference to that 45. As I indicated, the fact that I'm going forward with the voir dire of Mr. Paradise does not mean that I am ruling that a statement made in California after the defendant left without the firearm is admissible. But I will hear further argument on that issue after Mr. Paradise has testified.
Thank you.
And with respect to all of the other motions, parties are all in agreement that there've been, there are several motions pending, that there'll be no reference in opening, and including there were various motions. I don't see a follow-up to any of them on the other text messages and other statements between persons where you're going to provide counsel as to what those were, and nothing was ever then filed in court. So I'm assuming that anything that is the subject of a motion in limine will not be mentioned in the opening.
That's our assumption as well, Your Honor, yes.
And we can deal with it at 4 o'clock.
Yes, and Your Honor, the only text messages have been provided and I've been shown the ones that are anticipated in the opening.
Okay, so you've seen the ones that they anticipate using the opening, there's no objection to those?
The ones they showed us, that's correct.
Yes, okay. And we will see how many of the other ones we can deal with at 4 o'clock today. I think that we can bring the jurors back for both. I don't want to split up, obviously, your openings, and they can have, proceed to a lunch break after the openings. Thank you. We can bring the jurors back. Do you need a?
Can we take a 3-minute break, Your Honor, for a bathroom
Sure.
break?
Sure. Why don't you say 1:45 on this clock?
Thank you very much.
me. The lawyers have a chance now to make opening statements, which you should think of as something like a roadmap or a guidebook to describe to you the evidence that they expect we'll be seeing and hearing during the course of the trial. Remember this, the lawyers weren't there. The lawyers do not know what went on. The lawyers marshal the evidence, but they do not testify, so nothing the lawyers say is evidence. It's to reinforce that point that I don't hand out the notebooks until after the opening statements. Ms. McCauley, do you wish to make an opening? Yes. Mr. Barber.
Ladies and gentlemen, on June 16th of 2013, at just after 9 p.m., the defendant was leaving his home in North Attleboro with his fiancée, Shayana Jenkins. He texted Odin Lloyd. He told Odin Lloyd that he, the defendant, Aaron Hernandez, was going to come up to his house that night. And he, the defendant, and Miss Jenkins went to dinner and were alive. As the defendant left the house, he also texted two of his friends who were then in Connecticut, Ernest Wallace and Carlos Ortiz, and he secured their attendance to his house in North Attleboro. That night after dinner, the defendant returned to his house, and after midnight, the defendant, Aaron Hernandez, Ernest Wallace, and Carlos Ortiz were at the defendant's house in North Attleboro. They prepared themselves to pick up Odin Lloyd. With the defendant driving the vehicle, the three of them picked up Odin Lloyd outside of his house in Boston after 2:30 in the morning on Monday, June 17th. With the defendant driving, they drove to a secluded, isolated area in North Attleboro, a town where Odin Lloyd knew no one but the defendant and the defendant's fiancée, Shayana Jenkins. There, Odin Lloyd was shot 6 times. He was killed, and he was left in a secluded area. And when the defendant and Carlos Ortiz and Ernest Wallace left from that spot, when they left Odin Lloyd there, they left evidence at the scene. They took evidence with them. They created evidence of their cooperative effort, and they tried to, and in some cases were successful in destroying evidence. In the course of this trial, ladies and gentlemen, the Commonwealth is going to prove to you that the defendant committed the crime of possession of a firearm, he committed the crime of possessing ammunition, and he committed the crime of murder. Ladies and gentlemen, Odin Lloyd, at the time of his death in June of 2013, was 27 years old. This is a photo of Mr. Lloyd. He was born in the U.S. Virgin Islands. He moved to the city of Boston with his family at the age of 3.5 years old. He lived at the time of his death in the Dorchester section of the city of Boston with his mother and his 2 sisters. He graduated from high school in Boston. He played football, and he was on the track and field team. When he graduated from college, or from high school, there was no money from college, so he entered into the workforce, but he continued to play football in the league in the city of Boston. At the time of his death, Odin Lloyd was working for a fertilizer company, a lawn fertilizer company in Norwood. He was a very reliable employee, and he would get from his home in Dorchester to his job by taking a bus and then riding his bike to the business. Prior to his working there at the fertilizer company, he had worked for an electrical contractor, and that work brought him to the state of Connecticut at the end of 2011 into the beginning of 2012. He stayed at a Comfort Suites hotel there when he was working in Connecticut, and there he met Shania Jenkins, the younger sister of the defendant's fiancée, Shayana Jenkins. They began dating in March of 2012. That's what the evidence will be that you hear, ladies and gentlemen. From 2012 to the time of Mr. Lloyd's death in 2013, the relationship between Odin Lloyd and Shania Jenkins progressed. They spoke pretty much every day. Shania would call Odin while she herself was on her way to work. When they first met, Shania was working at the hotel, either on the 3 to 11 shift or the 11 to 7 shift, and she was attending college. By the time of Mr. Lloyd's death in June of 2013, Miss Jenkins, Shania Jenkins, she graduated from college. She was accepted at law school in the city of Boston, and she was planning to move to the Boston area, get an apartment, get a job, and be with little people. Now, as Shania Jenkins and Odin Lloyd's relationship progressed, Shania would come up to Boston to visit with Odin and his family, and Odin would go down to Connecticut to visit with Shania. When Shania came up to Boston, she would stay at her sister Shayanna's house. In the course of this trial, ladies and gentlemen, you'll hear evidence that Shania Jenkins, the younger sister of Shayanna Jenkins, and the defendant, Aaron Hernandez, grew up in the area of Bristol, Connecticut. Shayanna Jenkins and the defendant, Aaron Hernandez, dated in high school. The defendant left college to begin playing professional football. And when he did that, Shayanna Jenkins and he were together, and in November of 2012, they had a child together. They had the child, they bought a home in North Alabama. They moved in. That, ladies and gentlemen, between the time they bought that house and the time Odin Lloyd was killed, that's where he would visit if Shania was at her sister's house. In doing that, you'll hear, ladies and gentlemen, as it got close to June of 2013, that the defendant, Aaron Hernandez, invited Odin Lloyd into his basement to smoke marijuana with him. And in doing that, the defendant gave them money to Odin Lloyd to purchase marijuana on his behalf and roll it into joints. That was the nature of their relationship in June of 2013. The house that they bought, ladies and gentlemen, was 22 Ronald C. Meyer Drive in the town of North Attleboro, and when they bought it, it came with a home surveillance system. After the defendant and Shayanna bought the house, they upgraded the home surveillance system. They contacted the contractor that had done the initial installation, and they added multiple cameras as well as a digital video recorder. All told, in June of 2013, there were 12 cameras located on the inside and the outside of the house at 22 Ronald C. Meyer Drive. Some of them, because of the manner in which they had been upgraded, were now digital cameras. Some of them were older versions, and they were analog cameras, and they all wrote to the same digital video recorder. Because of the way they were installed, camera times weren't all the same, and they weren't all accurate. In the course of this trial, you'll hear, ladies and gentlemen, how all the cameras have been synced to the world clock so that they're all operating on the same time, notwithstanding the time that's imprinted on the video camera from the actual system itself. They've been synced, as well as other video surveillance evidence that you will hear. All of it's been synced to the world clock, so there's a standard time. You'll also hear, ladies and gentlemen, how the digital video recorder, because so much sometimes information is being written to the hard drive, will drop frames. And on the digital cameras themselves, it creates an unusual sort of stop action. And you'll get a chance to hear about that and see it for yourself. In the course of this trial, you'll also hear about other people connected to the defendant. You'll hear the defendant's cousin's name, Tanya. She lived in Bristol, Connecticut at the time this occurred. You'll hear about Ernest Wallace. Ernest Wallace goes by the name of Bo, or also as he was referred to by the defendant as Fish. Ernest Wallace, appeared in the defendant's phone under the contact fish 2, with the fish with the number 2. You'll hear that from February of 2013 through the time of Odin Lloyd's death, Ernest Wallace was referred to as the defendant's right-hand man. He did things for the defendant, and in exchange, the defendant gave him, among other things, rental cars to use. One of those rental cars was a Nissan Altima. The Nissan Altima was rented from an enterprise rent-a-car agency in the town of North Attleboro a week before Odin Lloyd was killed. He was driven by the defendant on June 17th to pick up Odin Lloyd. It was returned, even though it wasn't due, to the enterprise rental car the very next day, or that same day, late in the afternoon on June 17th. You'll hear about Carlos Ortiz, known as Charlie Boy, or as he appeared in the defendant's contacts, C-Boy, who was a friend of the defendant's from Bristol. He'd grown up with the defendant years before, and he was unknown to Odin Lloyd. Odin Lloyd, who he had never met. You'll hear about a man by the name of Oscar Hernandez, who the defendant met through a mutual friend, and to whom, on April 11th of 2013, the defendant deposited $15,000 into a bank account, and in exchange, ladies and gentlemen, you'll hear that the defendant received a gun. Now, with those players and that outline in mind, ladies and gentlemen, you're going to hear that in the time leading up to June 16th of 2013, the defendant and Odin Lloyd were texting back and forth. They were texting back and forth about the marijuana. And on June 14th, the defendant indicated to Mr. Lloyd that he was going to come and get him, and they were going back and forth about the defendant picking up the marijuana. On June 15th, in the early morning now, Saturday morning, the defendant arrived with his personal barber, who picked up Mr. Lloyd at his home of origins. They went to Rumor nightclub in the city of Boston. They got there late. It was almost closing time. Odin Lloyd had friends there as well. And during the course of that short time that all of these folks were in the club together, Odin and his friends were hanging out and having fun. The defendant appeared to them to be ignored. Although no words were exchanged at closing time, the defendant left the club angry. As he left Rumor nightclub, he went out onto Warrington Street, and his departure from the club was captured on video. You'll see the defendant walk in front of the car, with a sweatshirt and a hat. He's yelling back to this man who just comes in between the car, that's his barber. He's telling the barber to stay there. He's going to get the car. The car was a black Suburban, Chevy Suburban, that had been rented on the same day as the Nissan Altima in the same enterprise rental car in North Attleboro. The only thing is, the defendant didn't go with that car. He didn't come back. Instead, he was observed by a valet at the W Hotel just around the corner, in front of which black Chevy Suburban was parked, to be fixing a gun in his waistband and covering it with his shirt. The defendant returned to the corner, which you saw there on the video. And as he came back, within very few minutes, a crowd sort of formed. People were trying to take his photograph. Odin Lloyd and the barber came without Odin Lloyd's friends, and ultimately nothing happened there at the corner. They went back to the Chevy Suburban. And we sat in the Chevy Suburban, two young women, one of whom was the defendant's babysitter at his home in North Attleboro, came by. They were walking themselves from a different club to their car that was parked a few blocks away. The defendant told them to get into the car. He gave them a ride to where their car was parked. And they did. The defendant didn't go there. Instead, the two young women, Mr. Lloyd and the barber, with the defendant driving the Suburban, actually leave the city of Boston. They return to North Attleboro. They drop the barber off at his car outside of the defendant's house. And then, while the defendant is telling the young women it's going to be okay, he drove them to an apartment in the town of Franklin, an apartment that the defendant maintained. Ultimately, you'll hear, ladies and gentlemen, the two young women had to call for a car service early in the morning of June 15th in order to get back to their car in the city of Boston. The defendant himself was supposed to be at breakfast with his mother and his family, and he was not. As a result, his fiancée, Shayana Jenkins, set about to find. She called her own sister, who then in turn contacted old Lloyd in order to get in touch with the defendant. The defendant then sent Shayana Jenkins a text using Odin Lloyd's phone. And you'll see there, ladies and gentlemen, the text recovered from Mr. Lloyd's phone, the defendant indicating that he had made a mistake, he had messed up, he was on his way home. The defendant that morning, Mr. Lloyd, returned to North Attleboro with the defendant driving the Suburban. The defendant gave keys to the Suburban to Lloyd on that Saturday morning, June 15th, and told him, go ahead and return the car on Monday, so that Odin Lloyd would have a way to get back to the city of Boston, and the defendant went out with his family. But that afternoon, ladies and gentlemen, the defendant began rounding up his friends. He sent a text to Ernest Wallace, asking Ernest Wallace what time Ernest Wallace, his ninja, would return to North Attleboro at 3:15 in the afternoon. From that time to the evening of June 16th, as I indicated, the defendant texted and called Ernest Wallace and Carlos Ortiz more than 40 times from the morning of June 15th to June 16th. And on June 16th, the defendant sent those texts to Odin Lloyd, indicating first at 9:05, I'm coming to grab that tonight. That's Aaron Hernandez on the left side, and Odin Lloyd's response in the center. And after Mr. Lloyd agrees that I where at 9:37, and there's then, I'll figure it out, and hit you up. There's no further communication from Aaron Hernandez's phone to Odin Lloyd's phone. But after those text messages, ladies and gentlemen, the defendant texts his friends Ernest Wallace and Carlos Ortiz. He's imploring them to come up. And after those texts, there's also no further communication between Aaron Hernandez's phone and Ernest Wallace or Carlos Ortiz's phone. The defendant switches over to using Shayana Jenkins' phone. And from Shayana Jenkins' phone to Ernest Wallace and Carlos Ortiz, the defendant continues to maintain contact with them and continues to be apprised of how and where they are. And as you saw, ladies and gentlemen, those texts between Odin Lloyd and Aaron Hernandez, they don't come from Aaron Hernandez's phone. Aaron Hernandez's phone is later recovered. Those texts are deleted. Those texts that we saw come from Odin Lloyd's phone. You'll see, ladies and gentlemen, on the video surveillance, Carlos Ortiz and Ernest Wallace arrived at the home in North Attleboro after midnight. They alert the defendant. You'll have phone records that show that, and you'll see on the video the use of the phone. They're let into the house by the very babysitter the defendant had picked up and driven to Frank. Ernest Wallace and Carlos Ortiz arrived at the house and go down into the basement. As I told you, there are a number of cameras. The cameras in the basement that night weren't recording. You go down to the basement and they wait there for approximately 20 minutes or so, maintaining contact with the defendant. You'll be able to see on the video surveillance itself that they know the defendant's arriving. They come up from the basement and start looking for the defendant even before he pulls in. The defendant pulls in driving Shayana Jenkins' vehicle. He jumps out as the vehicle barely comes to a stop. He leaves the door open. He greets his friends in the driveway. You'll see, ladies and gentlemen, as they enter into the house, the defendant is carrying the gun. The defendant, Aaron Hernandez, Ernest Wallace, and Carlos Ortiz go down into the basement. They're there for approximately 15 minutes. After about 15 minutes, they come up and they begin to make preparation in the car. It takes approximately 7 more minutes back and forth into the house, into the basement, carrying things out to the car, in the trunk, before they finally leave. They leave after 1 a.m. And you'll hear, ladies and gentlemen, that a few days after the murder, the defendant makes a statement saying that he hoped the time of the murder or the homicide of Odin Lloyd would come out because he was at a bar at the time, or at a club at the time it happened. And that's not the case, ladies and gentlemen, because the defendant had been to a bar, the South Street Cafe in Providence, where he met with other folks, where he had dinner with Shayana Jenkins, and then he returned to his house. He left after 1 a.m. in the morning, and you'll hear and you'll have a chance to see from cell phone records, receipts, video surveillance, and other corroboration, including driving the route at the same time under same conditions by detectives 2 weeks later, that the defendant in the path that they take from the house to pick up Odin Lloyd and then ultimately return. What you're going to see, ladies and gentlemen, is that when they leave just after 1 o'clock in a rented Nissan Altima, Ernest Wallace is initially driving. They get out to Route 95. They don't head to Boston, where Odin Lloyd is. They head south along Route 95. At that point, they use Ernest Wallace's phone to contact Odin Lloyd. In total, from the time they leave, 5 telephone calls are placed from Ernest Wallace's phone to Odin Lloyd, who's in the city of Boston, at his house. The first one, Wallace's phone, connects with the cell phone tower right on the Rhode Island, Massachusetts line next to Route 95, South Attleboro. After that, they turn north. They use the phone again. It connects in the vicinity of Foxborough. They then drive up Route 95 and make the right, heading towards Braintree to 93 Southeast Expressway. They get off at the first exit, Route 138, and they stop at Blue Hill Express, a gas station. It's approximately now 2:03 in the morning. They stay there for 10 minutes. When they arrive into the gas station, Ernest Wallace is the driver of the Nissan Altima. Aaron Hernandez is. Aaron Hernandez is the driver. Ernest Wallace is in the front passenger seat. Carlos Ortiz is seated behind the defendant. And you'll see Carlos Ortiz has a towel around his neck. You'll also get a chance to see on this home video surveillance that when Wallace and Ortiz had arrived, that towel had been in Ernest Wallace's lap. It's now around Carlos Ortiz's neck. They stay there for approximately 10 minutes. It's all captured on video. you'll get a chance to see that. Leave, again, with Aaron Hernandez driving. They leave from the parking, or the pump area, and head back towards Route 128, and again, back towards Rain Tree. You can see the way the car is going. It's also corroborated by the phone records, because 3 more telephone calls are placed to Odin Lloyd from Ernest Wallace's cell phone. They show the vehicle heading up on the Southeast Expressway near the area of Melnia Cass Boulevard, and then ultimately the last telephone call at 3:22 a.m. hits off of a tower that covers the approach to Old Lloyd Street, Basin Street, in the city of Austin, Dorchester section. Basin Street is a one-way street. The tower shows a 322 telephone call, and then you'll see, ladies and gentlemen, Old Lloyd lived at number 10. Across the street at number 9 was a neighbor who had video surveillance outside this. It shows the Nissan Altima approaching and Odin Lloyd getting into it. The time is there. It's approximately 2:33 in the morning. Odin Lloyd's sister was sitting in a car just down the street and saw the whole thing happen. The defendant had told Odin that they were going to step out and that he would figure out what was going on. At 2:33 in the morning, ladies and gentlemen, there are no bars, there are no clubs open in the Commonwealth of Massachusetts. Video surveillance, cell phone data, toll records show path is then taken. Because even though now Wallace's phone is no longer used, and Ortiz's phone isn't being used, and the defendant isn't using his phone, Odin Lloyd's phone maintains connection with the cell phone network. And between cameras located at streets, video surveillance of businesses, Odin Lloyd's cell phone records, and toll records, you'll be able to see the route, ladies and gentlemen. They leave from picking up Odin Lloyd on Basin Street and make a right. They head back towards Route 93, then turn north a short distance onto the Massachusetts Turnpike, heading west, all the way out towards Route 128 and Route 95. At the Weston toll booth at 2:53 in the morning, the Nissan Altima, rented by the defendant Aaron Hernandez, proceeds through the toll without paying. It's captured by photograph. From there, the cell phone information and then video surveillance shows that the vehicle heads south onto Route 128-95, continues on Route 95, getting off of Route 95 at exit 5, North Attleboro. Coming off of the exit, it's a right and then a quick right into the North Attleboro Industrial Park, known as John Beach Boulevard. There's surveillance at that location. There are very few cars on the road. There is Odin Lloyd's cell phone. It was 3:20 in the morning. That is the direction from there to the defendant's house. And you'll see, ladies and gentlemen, that just under 10 minutes later, the defendant arrives back at his house. He's still driving. You'll see, ladies and gentlemen, driver's side mirror is missing. Despite having picked up Odin Lloyd at 2:23, only 3 people returned to Aaron Hernandez's house. Aaron Hernandez, Ernest Wallace, and Carlos Ortiz. The defendant inputs the code into the overhead garage door opener. The three of them duck quickly before the door is even completely open into the garage. The defendant leads them through the house, telling them to be quiet. His fiancée and baby. Ernest Wallace and Carlos Ortiz initially go down to the basement. Over the next few minutes, you'll see during the course of the trial on the video surveillance, the defendant is moving around, comes down from the first floor into the basement, moving around on the first floor. And you will see, ladies and gentlemen, the defendant standing outside of the entrance to his basement holding a gun. In the course of this trial, you'll hear from a representative of the law. He'll tell you, ladies and gentlemen, that that appearance is unique. That, ladies and gentlemen, is the law. Now, you'll also hear that the defendant is scheduled to be at his work in the morning, June 17th. Lloyd is scheduled to be at his work on the morning of June 17th at 7 o'clock. Neither of them appeared. Instead, in the course of the trial, you'll have a chance to take a look at the surveillance video of the house. You'll see that shortly after the defendant is seen with the Glock, the cameras, the digital cameras, are shut down in the house. They're not turned on until the afternoon of June 17th. And sometime after 1:30, approximately 1:44, so the defendant wakes up Wallace and Ortiz, who were down in his basement. They play with his baby. You'll see during the course of the trial that the defendant leaves Carlos Ortiz with his baby in the pool while the defendant himself goes back to the Nissan Altima and retrieves evidence, a magazine clip for a firearm. You'll see, ladies and gentlemen, that the defendant, Carlos Ortiz and Ernest Wallace, leave from the house in the Nissan Altima just before 5 p.m. on June 17th. They take the Nissan Altima to the Enterprise rent-a-car. The defendant says to the manager there that he's returning it because the car has been cracked up. It's not due back. She asks the defendant, the manager asks the defendant, how did it happen? The defendant says that he didn't know. He doesn't crack up cars. Somebody cracked it up, and that's why he's returning it. They get in exchange a Chrysler sedan, and they return back to the defendant's house in North Attleboro. At that time, or at the time before they leave, there are no items being taken out of that basement being put into the car. You'll have a chance to see that on the video. Sometime shortly after 5:15 p.m., Ernest Wallace and Carlos Ortiz leave from the defendant's house. Their cell phone records show they actually go to Franklin, Massachusetts. Just shortly after, 15 minutes later, Matt Kent, a young high school student, was running through the area of Corliss Landing. As he actually lived in the same neighborhood as the defendant. He had been taken to a gym in the southern part of the North Attleboro Industrial Park. He was dropped off so he could work out. He was running home, coming through Corliss Landing as part of his workout. As he did that, he saw off in the distance the body of what turned out to be Lloyd. He could immediately detect there were no signs of life. He, being a young man, went and got adult help. When the adult help returned, they also saw that there were no signs of life. They gentlemen, is that an investigation then ensues. As I told you, at 3:20 in the morning, the defendant turns north heading on John Beach Boulevard. What you'll hear, ladies and gentlemen, as you head north towards the defendant's home on John Beach Boulevard, as you get towards Metalore, a metal refining business, the road takes a sharp right-hand turn. Metalore